Good evening. How are you?
Hey, good evening. Good to see you.
Yeah, apologies. The title of your book. Can we get that out?
It is Corrupted by Fear, How the Charter Was Betrayed and What Canadians Can Do About It.
Excellent. What caused you to write that book?
Well, so much went on for 4 years. We got some really bad court rulings, and it really took a while for all of it to sink in, just how atrocious these court rulings were, that we have judges basically repeating what they've heard on the CBC and making assertions in their court rulings that are not based on evidence before the court, which is a very serious problem. And I appeal to people as well who supported lockdowns and supported vaccine passports to say you should be really concerned when judges are repeating a media narrative in their court ruling that's not backed by evidence. If we accept that as being okay, it just opens the door even wider for governments to violate our rights and freedoms and not be held to account by the courts.
Well, the title is Corrupted by Fear. So you're considered as a type of corruption or coercion or trying to get people to do something when it's not what they normally would do. That's really what corruption means. So why would it be corrupted by fear? Do you think this is intentional on their part?
I can't look into the hearts and minds of judges to know what's intentional or not. But the title emerged because at various public meetings, I leave Calgary roughly once a month and I go to Medicine Hat, Lethbridge, Edmonton, Vancouver, Toronto, Montreal, you name it. And usually when I'm out of town, we have public meeting. And I got asked so often in 2021, 22, 23, 24, in the last few years, I keep on getting asked, well, what's going on with these judges? Are they getting paid off? Are they getting bribed? Are they getting a threatening phone call from the Prime Minister? And my answer has been no. I do not believe for a second that the judges are getting a thick envelope full of $100 bills. I don't believe that Trudeau or judges or the World Economic Forum is phoning judges or threatening them. But what creates this departure that I've not seen before in I've read thousands of court rulings during law school and the years thereafter, and I've never seen this departure where judges are just not even explaining why they're ruling for one side and not the other. So they rule for the government. They say, well, the government's evidence is better, it's stronger, it's more persuasive. They never explain why or how the government's evidence is better or stronger. And so I think, okay, they're not getting threatening phone calls from powerful people. They're not getting envelopes stuffed with cash. What is driving the judges to not look at the evidence that's been placed before the court? And my thesis, and I don't know what's in their minds and hearts, my thesis is fear. They got corrupted by fear the same way that millions of other Canadians fell prey to this round-the-clock, every hour media fear-mongering, making false claims by exaggerating how bad COVID was and making it out to be far worse than what it was. And the judges fell prey to that, so they were corrupted by fear.
I think that's a really good assessment. And what you identified is, and that's where media can play the role. So let me just highlight the Coots situation. I think you're familiar with that down in Lethbridge, King's Bench. And we'll just talk about the bail. The way the bail system is set up is, especially if you're charged with something like murder or attempted murder or conspiracy to commit murder, it's a reverse onus. And it's actually on the defendant to go ahead and show that they're not dangerous. So with the Chris Carber, Tony Olenek, Chris Lysick, and Jerry Morin, their bail, the judge was handed ITOs. ITOs are information to obtain. And these are basically real world narratives at the time that the police, fictional or not, put together for the court to consider. And these were fear-based. So we had the Canadian Anti-Hate Network in there. We had Vice Media in there talking about a national organization that had all of these resources ready to take over Canada. And it was a real fluffed up piece. And if you listen to the RCMP press conference on February 14th, 2022, you really would have thought we were just moments away from being taken over by an organization. So there's a lot of fear there. And because of that, bail denied. And you would think, rightfully so, given the information then. Fast forward a couple of years in the trial, the jury dismissed and found not enough evidence to convict the men on those particular charges. So they were vindicated, or at least acquitted, on conspiracy to commit murder. But they stayed in pre-trial with no bail based on those decisions, and that was 100% fear-based. The defense could not convince the judge there's no fear here. These are not dangerous people because of the narrative created by the media, used by the Crown and the RCMP. Is that the kind of fear-based corruption you're talking about? Because these people were in jail pre-trial.
The short answer is yes. I have not followed the Coutts proceedings closely, and it's not a lack of interest or concern, but there's a lot on my plate, and the Justice Center lawyers, that was not one of our cases, so I was not following it closely. But everything that you just said, it aligns 100% with what I've seen in the court rulings that I've analyzed in the book, where, as one example, in the Gateway versus Manitoba decision, the judge declared that COVID was unprecedented and that it was the worst pandemic in a century. And both of those claims are not supported by no evidence before the court. COVID was not unprecedented. We had the Spanish flu of 1918, which was 100 times, if not 1,000 times worse. And we had the Asian flu of 1957, the Hong Kong flu of 1968, both of which were more deadly than COVID. And so the judge makes these false assertions. And of course, he doesn't reference any evidence. I mean, there's no evidence to support them. And he writes this into his court ruling as if this is some finding of fact that he's entitled to make, when it's 100% based on media fear-mongering.
Yeah, correct. And I was about to say that, the media fear-mongering, because that's all he's running with, or she, is the talking head on the screen that just replicated whatever the government said. How does judicial notice play into this as well? Because this was taken on several issues with the courts.
Well, one of the most egregious examples was a judge in Saskatchewan, Michael McGaw, appointed by Harper, not by Trudeau. And he ordered a 12-year-old girl to be injected with the mRNA vaccine, contrary to the girl's wishes, contrary to the mother's wishes. And if that wasn't bad enough already, he went on to take judicial notice, which it's not a bad tool in a judge's toolkit. If you're dealing
when used correctly,
if you're dealing with somebody who says that the gravity doesn't exist, or the earth is flat, or something, there's a certain line in the sand where the judge is going to say, look, I'm taking judicial notice of X. And so it's a valid tool, because you can't have in court cases that, every crazy idea needs to be proven with evidence. But it's been abused. So here the judge went on to say that he took judicial notice of the fact that the mRNA vaccine is safe and effective for adults and children. And he says he bases this on assertions made by Health Canada and the Saskatchewan Health Authority. So it's like a government asserts that a vaccine is safe and effective, therefore it is. And it's a very sick, perverse, extreme deference to government that is not warranted, and no court in any circumstance should accord that kind of deference to government.
Requirement of the mandate that the government was in the right to do that. In Alberta, we kind of had the Ingram decision, which did a bit of a test for Section 1 and came to the conclusion that it was reasonable and demonstrably justified. So we did kind of have a small challenge around the effectiveness and the mandates, but the government's narrative upheld. And now we have, and I know you've been paying attention to this one, the Bill of Rights here in Alberta. We've had some modifications to it. And I don't know if it's going to protect us next time around. Do you have a comment on that one?
Ultimately, our rights and freedoms are protected by culture, which means that if 50%, 70%, 90%, the higher the better. If Canadians cherish constitutional rights and freedoms in their hearts and understand them with our heads, then that's really what protects our rights and freedoms. If you think back to 1982, before the Charter, we had a common law understanding that criminally accused person had the right to remain silent. So no confessions can be extracted by use of torture. The right to remain silent, the presumption of innocence, onus on the Crown to prove guilt beyond a reasonable doubt. and the right to a fair trial before an independent judge, and the right to face your accuser and to question your accuser or have your lawyer question the Crown's witnesses. All of those things were solidly entrenched in our legal system without a charter, and that shows that it worked because 99% of Canadians just understood that a man is innocent until proven guilty and has all these procedural rights. And so we've had a cultural decline, and unless we reverse that, the wording of the charter or the wording of the Alberta Bill of Rights is not going to save us until we ourselves and we educate ourselves and our children and our grandchildren about the free society being morally superior to repressive regimes, whether they be communist or fascist or theocratic or anything else.
I like the way you put that, and it is up to us to teach our next generation and the people around us. So thank you very much for doing shows just like this, and for all your work at the JCCF, because this is part of what you do is education, and you're trying to teach people as well. This current matter that you're going into, so you put out a post, I think it was on the 9th of January, that there's a lawsuit about the proroguing of the government. Before we jump into that, can you tell us what does proroguing Parliament mean, and what are some of the consequences of that?
So the prorogation of Parliament is kind of halfway between two extremes. One extreme is you dissolve Parliament and elections follow after Parliament has been dissolved. And with the dissolution of Parliament, all parliamentary procedures stop, not only question period, but the committee work, the right of committees to ask questions of cabinet ministers, the right of Parliament to hold the government to account. Everything stops. Every bill that is, whether it's passed first, second, or third reading, unless it's been proclaimed into law, every bill dies. So that's dissolution followed by an election. On the other extreme, you can have an adjournment of Parliament or a recess of Parliament, which means that there's no daily question period, but otherwise Parliament does continue to function with its committees and being able to hold the government to account to a considerable extent, even without question period. Prorogation is halfway between the two. Prorogation means that Parliament is shut down entirely, just like dissolution, but there's no election following prorogation. And so it is appropriately used when a legislative session of Parliament, which could be for 10 months or 2 10-month periods, when that comes to a natural end and the government's business has been concluded, the government has tried to pass legislation in keeping with the throne speech. And so prorogation of Parliament is not a bad thing, but it should be used in the national interest when Parliament is kind of naturally winding down. And after prorogation, you need a new throne speech to start off the next session of Parliament. So our court action is saying that Trudeau's use of prorogation in this circumstance serves only the benefit of the Liberal Party of Canada, does not serve the best interest of the country. So it's an abuse, it's a wrongful use of prorogation. And we're saying that the advice that he gave to the Governor General was unlawful or illegal. And so we're asking court to set aside the prorogation. And we're relying on a very strong precedent 2019 decision from the United Kingdom Supreme Court.
Yeah, kind of interesting that it's a very recent decision, because in the UK they tried to do the same thing, did they not? Can you take us through what happened over there and what led to the Supreme Court decision for them?
So in 2019, Boris Johnson became Conservative Party leader and Prime Minister of a minority government, and he was intent on seeing the results of the referendum honored sooner rather than later. The British had voted by a narrow margin to leave the European Union in 2016 in a referendum. 3 years later, these negotiations were ongoing, and they could never work out the details of what the departure of Britain would look like. So Boris Johnson's view was, we have to tell the European Union that if we can't come to terms and agree on the details, we're going to leave the European Union without a deal. So it was a no-deal Brexit. He favored that, but the majority of MPs, because he had a minority government, were not in agreement with that. They wanted to continue negotiations. So Prime Minister Boris Johnson prorogued Parliament for 5 weeks. Usually it was only 1 to 3 weeks that Parliament was prorogued. He prorogued it for 5 weeks, and immediately court actions were filed. and they made their way up through the chain all the way to the Supreme Court. From the time the first action was filed in a lower court until the United Kingdom Supreme Court rendered its decision was about 4 weeks. So they handled it quickly. And the court ruled that this prorogation was illegal because the Prime Minister was trying to avoid the scrutiny of Parliament on this very important issue of the how and when the United Kingdom would leave the European Union. And so they noted the principle of parliamentary sovereignty and that the government is accountable to Parliament. So Parliament is above the government. Government needs to enjoy the support of the majority of the MPs. And this is a longstanding ancient principle, which they felt Boris Johnson was violating by proroguing Parliament in order to avoid scrutiny. And they said that is improper. And so we are arguing in our Canadian court action that those principles from that court ruling should be applied here in Canada because Trudeau's prorogation of Parliament was illegal. It was done only for the benefit of the Liberal Party of Canada, and that's not a good enough reason to prorogue Parliament.
Yeah, you're right, because he did his faux resignation or resignation with conditions. He did that, and then he prorogued at the same time. So that wouldn't normally be the case. So Trudeau Senior, he resigned as well. Did he prorogue the Parliament?
I believe not, but I'm not sure. I'd have to look at that. I don't think so.
Okay, so I think your position here is there was no benefit to the people at all to have the Parliament prorogued, other than maybe some bills dying that aren't popular. But the committees all stopped, correct? Everything that was being investigated and worked on has stopped?
Yes, right now, Prime Minister Trudeau and the cabinet are ruling the country for 11 weeks. That's the problem, too. It's part and parcel of this. If he had prorogued Parliament for a week or 2 or 3, okay, fine. Parliament will be back in session and can proceed with a non-confidence motion if MPs want to go in that direction. This is 11 weeks. It's almost 3 months where we have a government that is operating without any accountability to Parliament at all. He could have just adjourned or recessed. That would be different. But this prorogation is a total shutdown of Parliament. And so it's just not an appropriate use of prorogation.
Now, it's coming back March 24th, unless you're successful and it comes back even sooner. But what's special about that date? Something about some costs and some budget needs to be addressed? Do you know anything about that?
If Parliament does not meet again to approve of the government's expenditures, it means the government cannot spend money after March 31st. So they do have to come back to authorize either a new budget or an interim budget. They have to authorize continued spending past March 31st. So that's why he didn't want to prorogue it longer than that. But again, 11 weeks to March 24th is too long of a time.
Yeah, and we're likely coming back with a different PM too when that comes back. So how would that work? So Carney, he put his hat in a ring. It's official now. He's running, and they're expecting to have a result for March 9th, I believe. They said they'll announce the new leader. So how would that work? Like on March 10th, he gets the keys to the PMO, or is it on March 24th when we come back? Like, how would that work?
Well, technically, the country or a province could have a prime minister or premier who is the premier, but who is not elected to the House of Commons. By tradition and as a constitutional convention, that cannot be a permanent state of affairs. So it's okay under our system for a new person to win the leadership race of the governing party. You take Danielle Smith in Alberta. She won the UCP leadership race. She became premier, but there's grounded in tradition, there's a very strong understanding, and I think if we had to take it to court, this would hold up, that it's part of our constitution that the prime minister must be a member of the House of Commons, or the premier must be an elected member of the Legislative Assembly. So Danielle Smith was premier briefly without being an MLA, but as soon as reasonably possible, she ran in a by-election and became an MLA. So in similar fashion, we could, if Mark Carney beats out Chrystia Freeland, then we could briefly have a prime minister who was not a member of Parliament. but everybody understands that that's not a situation that you can carry on for months or years.
Yeah, but is there a law that requires it? If you're using the word tradition and understanding, that makes me nervous when we're dealing with the Liberal Party, because we understood what the Emergency Act was meant to be used for, like last resort, like we have no other choice. But they pulled that tool out pretty quick, and reasonably justified and demonstrably justified. Again, they have a very different definition than we did. We went through the POEC, we heard their arguments, and then Mosley came along and basically said, no, you guys really didn't have it. So when I hear things like, well, traditionally and constitutionally it's implied, that makes me nervous, because unless it's in black and white, I don't know if they're going to be forced to. Is there anywhere that you're aware of that will require them to call an election, let's say by October?
Well, if the Parliament comes back into session on March 24th, and that would be with a throne speech and legislative agenda, so on and so forth, then right after the throne speech, one of the MPs could say, Mr. Speaker, point of order, I have a motion of non-confidence in this government.
Yep.
And that right after the throne speech, you can have a vote of non-confidence, and immediately you go into an election right then and there. In terms of it not being written down, this goes back to the importance of that this love for freedom grounded in justice based on truth, not an unhinged freedom that can fly in any direction, but freedom in a proper context, rooted in justice. If that's not enshrined and reigning in the hearts of people, and if it's not understood by the mind, then you're really in deep trouble, because then you end up having to go to court if the government said, well, we're going to have an unelected prime minister running the country just because he won the leadership race of his party. We want to be in a situation, even here with prorogation, where it's just understood that you don't abuse prorogation for the benefit of one political party just because they need to, they need time to get their act together and elect a new leader. That's not a constitutionally valid reason. So it's similar to people understanding prior to 1982 that an accused person has a right to a fair trial and has a right to be presumed innocent, et cetera, et cetera. That was not written into, we didn't have a charter. It wasn't written into a document per se, but there's this profound understanding. Everybody understood, the judges, the lawyers, the people, the prosecutors, everybody understood that there's a presumption of innocence and we have a right to a fair trial.
Now, that's under normal times, and I would even argue peaceful times. But what happens under emergencies? If there's an economic emergency or some sort of health emergency or a combination of many emergencies, do things start to change under those conditions? Would there be a requirement to have, let's say, an election if we were in the middle of a war or we were having an economic collapse, like a full-blown one? So what could happen if an emergency is happening to Canada?
Well, we have a precedent in the Commonwealth. In India in the 1970s, we had Prime Minister Indira Gandhi, who was democratically elected. I don't know if she was in her first or second or third term, and she declared a state of emergency because there was a severe economic crisis, and this ended up with journalists being locked up, and it was a martial law. And basic rights and freedoms were taken away from the people. And the state of emergency lasted, I don't recall whether it was months or 1 or 2 years. So, I mean, conceivably that could happen in Canada, but then that gets back again to what is the cultural acceptance? What are the cultural expectations? If you have 90% of Canadians saying, no, this is totally unacceptable, that's going to trickle up to the senior civil servants and the army, the military, the Air Force, the courts, the judges. If the whole country is on side with this idea that you need a true emergency, but I have to agree with you. It is frightening when you saw how blithely, cheerfully, and sometimes enthusiastically Canadians gave up their basic rights and freedoms based on media fear mongering and false claims about COVID being, far worse than what it actually was. And if people are willing to give up their rights and freedoms and allow themselves to be propagandized by government-funded media, I can't dismiss your concerns. I would say, well, this is where we really have to hope that these rights and freedoms are sufficiently respected and understood and cherished by 90 or 99% of the population. That's the safeguard.
Okay, well, okay. Let's hope we don't have to get
Well,
there. But let's say,
we did see,
okay, one of the
we did see, we saw these terrifying arguments during the Public Order Emergencies Commission.
Right.
We saw these senior bureaucrats saying, well, we should broaden the basis for what could be a national emergency. Like if there's severe economic problems, we should be able to start issuing emergency decrees, and where you can freeze bank accounts because unemployment and inflation are running rampant. I mean, that's frightening. But they were actually suggesting that the Emergencies Act boundaries, which were violated by Trudeau and one of the Justice Centre's court actions, resulted in played a role in that ruling that was issued in January 2024, where the federal court said that there was no national emergency and the Prime Minister acted illegally when declaring there to be a national emergency. There you go.
Yeah, I was there when Freeland was testifying, and I paid very close attention to her. And she quite literally said the economic reputation of Canada on a global stage was enough to cause an emergency, because if we couldn't attract investment and battery factories and this kind of stuff, because it was Stellantis who called her and said, hey, look, we're concerned about this Windsor border thing. We need you to take action. And she said that was enough for her, in her mind, to say that we were on the verge of an economic collapse, which is more of a testament to her function as the finance minister at the time, because really we shouldn't be on the verge or on a cliff of any kind. But that's what she was testifying to, economic emergency, and that was enough in her mind. And if we have something like, I don't know, Trump with his tariff things, he's talking about using economic force against Canada to kind of force us into maybe joining them. Like, this is all rhetoric happening right now, and it may not materialize. But I can see how quickly, if we got into empty shelves and we couldn't get produce out of the U.S. or something, that Canadians could see it as an emergency. And as you saw, John, it just takes the media to say emergency. The government doesn't even have to use that word. But the media could, and boy, they can get a lot of people to fall in line pretty quick. Now, you did say trigger with like a non-confidence vote, but Carney met with Singh. The rumor out there is they struck a deal. So what deal could they have struck? Is he going to hold off until October? Is there some sort of spending that they're going to agree to? I think Canadians would put up with October, but not any further. Like, if we don't get to the election that we had set, October 20th, 2025, I think Canadians will lose their mind. But is it possible with consent from NDP that Carney could stay unelected because we're so close to an October election? Maybe the Governor General agrees, and we could actually see that all the way to then?
I don't have the answer to your question as to, what is the legally required time period, if any, when, again, let's say it's Carney, right? If Freeland wins the Liberal leadership race, it'd be a lot simpler insofar as she's already an MP. Freeland could make, if she wins, and if we're not successful in our court action, and if Parliament comes back only after the 11 weeks have elapsed, so they come back March the 24th, we could see Singh, keeping a Freeland minority government in power the same way that Singh kept Trudeau in power. So it is conceivable, yes. Now, but if Carney wins, I apologize. I don't know whether there's a constitutional convention or tradition or requirement as to whether he needs to run in a by-election immediately within a month or 6 weeks, or whether he could govern for six. If he could govern for months on end. You probably see another court action filed to get a court ruling on what the status is, and can a prime minister who is not a member of Parliament rule the country for months on end. I could see a court application being brought to get clarity on that question.
Yeah, my research says the Governor General would approve or disapprove it. It would be on the request of the PM. And if Carney says we're prepared to do the election in October because of the Elections Act, it's a set date, it's the next set date, and we'll do it then. And if we're having this conversation late March, the Governor General might say, all right, like, it may not be worthwhile having a by-election and then a couple months later have an election. So it might be conceivable that they even say, for the price to Canadians, it's probably best to just wait till the election. And if that's on consent, because the NDP could actually agree with that. So it'd be a harder argument if Canadians had to go to court, I think, to force it. So let's talk a little bit more about yours. What's the remedy you're looking for? Get the Parliament to come back?
Yes. In the United Kingdom, the Supreme Court ruled that the advice given to the Queen, at that time was Her Majesty Queen Elizabeth, the court didn't fault her for taking the advice of the Prime Minister, because that's just a convention. And I would not want to, go after the Governor General of Canada for having, accepted the advice of the Prime Minister. That's how things work. But in the United Kingdom, the court got around this in a very clever way. They didn't criticize the Queen, and they didn't say that the Queen should have rejected the advice of the Prime Minister. What they said was the Prime Minister's advice to the Queen was unlawful. So they attacked. Well, the court didn't attack. They voided. They said the Prime Minister's advice to the Queen was unlawful, and then they said prorogation of the British Parliament was null and void. And so we're going to carry on as if Parliament had not been prorogued. And the very next day, all the MPs, I saw this on YouTube in the past week, all the MPs were back in the House of Commons, and the opposition MPs were basically reprimanding the government and holding the government to account for its saying, look, you prorogued Parliament illegally. This is a disgrace. And the government ministers said, no, we did this in good faith, and it was the right thing to do, and we respect the court's decision, but we did act in good faith. And so you had this debate the very next day. So what we're hoping for as a remedy is that the court would say that the prorogation was null and void, and MPs are going back to work the next day, and that would open the door for a non-confidence vote. It would also provide another opportunity to the NDP leader to keep the government in power and say, well, we're going to allow the Liberal Party a whole bunch of time to have its leadership race.
Yeah, that would be interesting on how that works. Now, how quick can you get into court? Like, do you have a court date? It's not going to be April, I hope. So how quick can you get into court for this?
So we filed our papers on Tuesday, the day after the Prime Minister announced his forthcoming resignation.
You guys are quick.
We've got some fantastic lawyers. We've got James Manson is one of our Toronto lawyers and doing a fantastic job on this file. And so we've asked for an expedited hearing, which every litigant is free to ask for. We don't want this to become some moot point. We don't want the government to be arguing in March or April that it's moot and we shouldn't get a ruling. And so the delay tactic started immediately, because the first thing that the Crown said was, they said, we're not prepared to provide you with our position as to whether or not this should be urgent. We need time for that. We want to come back next week just to tell you what our position is. Fortunately, the court did not take kindly to that and said, well, you're coming back very soon to tell us if it's urgent or not. So they came back a day or two later and said, our position is that this is not urgent. So now they're forcing us to make a formal application for a ruling that this is urgent. So that's been made. The government earlier today submitted apparently 200 pages of court rulings and documents and an affidavit, so on and so forth, to argue that this is not an urgent matter that should be moved forward quickly. We're expecting a ruling. We think we have a good shot at winning, but I'm not making predictions. But we're expecting a ruling between now and Monday morning that the court will say, no, this is going to be expedited. And on Monday afternoon, we hope to be back in court to nail down a timetable where we're going to have the court hear the application, hopefully before the end of January, and issue a ruling, hopefully in early February. And so, we're going to have this move as quickly as possible. And as well, if there's going to be an appeal, which there very well may be, if we lose, we'll appeal. If the Crown loses, they'll probably appeal. And Federal Court of Appeal can also hear this very quickly, I think.
Well, you guys moved pretty quick, but a 200-page response on why this isn't urgent. It sounds like maybe they were ready for some of these challenges, because that was pretty quick for even them to turn around, don't you think?
Well, I haven't read the 200 pages, but I'm told that they don't really have strong arguments as to why this should not be urgent.
Well, yeah, they set a time to come back. We got 11 weeks to hash this out, whether or not it was legal. And we know they like the moot argument, right? We've seen this
Oh,
a couple
yes.
times already.
Sadly, yeah.
Yeah. So hopefully you're very successful and get that. I'm not going to make a prediction, but if this isn't urgent, then what is? So if this shouldn't be expedited, what should be? Like, what would be the threshold if it's not something like this? Our government is shut down. We have a complete stop to the process of Parliament. If this isn't urgent, I don't know what could be. Is that basically your argument? Like, what could
Yes.
be an urgent? Yeah.
Yep.
Yeah. Well, I'm sure they're going to have a good response. Is this public? Are you guys sharing all of this? Are you publishing it like on your website or anything?
James Manson has done, I believe, 2 separate videos. One of them got 360,000 views. I'm jealous. But
We'll see what we can do tonight for you.
But James Manson, I anticipate, will be releasing another video soon, as soon as there's something to report. That'll be coming out, if not on Friday, then on Monday. And if it's not a video by James Manson, it'll be a news release from the Justice Center to provide an update. And so we're going to keep our supporters and all Canadians informed.
Is this going to be streamed in any way? Are there going to be any open court? Are we going to have a Zoom link? Do you know if we can get any of that?
I believe not, but I'd have to get back to you by email and check with James. But I don't believe this is going to be live streamed from the courtroom. It'd be great if it was, though. I think we'd get a lot of people watching. Well,
actually, on that topic, why isn't everything available to the public, like live streams and transcripts? And why is it really kind of in publication bans? Like I was about to say to you earlier, it's not your fault that you don't know much about Coutts and what happened in Lethbridge, because there's publication bans in place and it's hard to even get information out. So how can you deal with some of those?
Well, the courts move at a slow pace and they are in charge of their own procedures. I don't see a reason why courts, would not or could not, for example, post the factums and the briefs. And I believe that's not the case. They definitely post their rulings, and that's fine. Yeah. But with the internet, there's no reason why they couldn't put on the plaintiff's factum and the defendant's factum. Certainly in important constitutional cases, you could see all of that. The Justice Center, we're doing our part. For example, on the court cases that are referenced in my book, we are posting the government's evidence on our website so people can see with their own eyes, can read through it and see how pathetic it is and how the governments are not placing compelling evidence to justify lockdowns before the courts. They're making a lot of assertions. They're claiming lockdown saved lives. They're making false claims like, COVID is the worst global pandemic in a century. It's unprecedented. The government makes all those claims in its evidence. But the evidence to back up those claims is not there. People will be able to see that when they go to our website and see the government's documents that we're posting in respect to these constitutional challenges.